Will former FBI Director Jim Comey go to jail? How will the court handle birthright citizenship? And Spirit Airlines, they're gone. Will Chamberlain from the Article 3 Project is here to break it all down with us. Welcome to the Sean Spicer Show. Let's get into it. All right, guys, good Monday to you. I hope you had a great weekend. A lot happening. First female trainer won the Kentucky Derby. Big deal, big deal. Congratulations to her. I didn't. I was at home signing book plates to send out to people. And sometimes people ask me, what's a book plate? It's a little thing like this. It's a sticker, basically. You can insert it in your book right at the beginning here, and you put it in, and it makes it a signed book because I'm a political hoarder. I love collecting memorabilia and all sorts of stuff. And thanks to everyone. We made Trump 2.0 a bestseller over the weekend. Let's continue the momentum, my friends. I told President Trump I would put this on the bestsellers list. So thank you for everybody. If you're still interested in getting a signed book plate, send a screenshot of your Amazon purchase to contact@seanspicer.com, or send a screenshot of your Amazon purchase to contact@seanspicer.com, and we will make sure that we send you out a book plate for Trump 2.0. But thank you for helping. And obviously the other thing is, please go to Amazon and hit that 5-star review. That's super important as well. We got a lot to break down with Will Chamberlain of the Article 3 Project. So stick with us. This is going to be a great show because there's so much legal action taking place in the court and everywhere else that I want to break it down with you. But a lot of other news happening. Iran, there's a big President Trump trying to make headway in keeping that Strait or Hormuz open, the Navy offering to help ships get guided through. But he had some other big weekend because the Pentagon released a statement that the blockade has already cost Iran $5 billion. Think about that for a second. That's $5 billion that they are spending on defense. They're not spending it on terrorism. That is so good to hear. You understand, sometimes that news doesn't get out to people. $5 billion that they've been deprived in trying to kill Americans, right? And when we talk about things that have cost money, how can you put a price on how many people are now going to be alive because Iran was deprived of the ability to keep funding terrorism? And like I said, the Navy now being put on notice from President Trump that they're going to help try to get ships through. This is big deal because the president is definitely giving them as many options as possible before hopefully he renews bombing rather. So there's a lot of great stuff there. A lot of the things that I want to update you on the redistricting, because here's the deal. A lot of people are calling me and saying, what's the latest? Alabama today started a special session. They've got another court order. I think they will revert back to their last cycle maps as a bridge to get forward. So it'll become a 6-1 map. Next cycle 7-0. That's additional pickup. Louisiana redoing their district maps right now. That's going to net us 1. A lot of pressure in South Carolina. Governor McMaster telling the state Senate, get your act together. There's one district there that's held by Jim Clyburn. I think we can get that district, but they need to keep that pressure on the state Senate president to call a special session. Brian Kemp, the governor of Georgia, pissing off a lot of people, saying he's not even going to try. No surprise there. Tennessee entering a special session largely because of the efforts of Senator Marsha Blackburn pressuring the governor there, Lee, to move forward with a special session. And Mississippi going to a special session, but they're not clear whether or not they're going to be able to pull off the congressional lines before the map. So a lot of big action happening there, which is positive to help keep Trump 2.0 agendas moving forward into this midterm, after the midterms, fingers crossed. But also over the weekend, Spirit Airlines crashed. Literally, it's out of business. And I think you have to understand the why. I want to tell you something that this is Elizabeth Warren, by the way. She talked about this in March of 2004 when Biden was still in office. She said, I've warned for months that a JetBlue Spirit Airlines merger would have led to fewer flights and higher airfares. She applauds the Justice Department and the U.S. Department of Transportation to stand up for consumers and stop that merger. Okay, so just to be clear, there was a plan. JetBlue would have bought Spirit Airlines. They would have had a very small market share. And the Biden DOJ and the Biden DOT, Merrick Garland and Pete Buttigieg, said no. And now what happened? Spirit Airlines, which had filed bankruptcy multiple times, finally said enough at 3 a.m. Saturday morning. Done. Consumers are screwed. And then all of their pilots and their workers, flight attendants, etc., are out of a job. out of a job. And these guys, because of Mayor Pete and all this, that's because of them. So I'm just telling you, they caused this. I'm going to ask Will Chamberlain in a couple seconds whether or not the government should have gotten involved or not. But anyway, again, thank you for all the support for Trump 2.0. Continue to go to Amazon and buy that. On Wednesday, the president's pollster, Jim McLaughlin's going to be here. And then on Friday, we've got a great new look at a book that Jan Ukalik has put out called Killed to Order, a New York Times bestseller about baby parts in China that is unbelievable. He's at the Epic Times. This is going to be an unreal show. You're not going to want to miss this on Friday. Before I bring in Will Chamberlain of the Article 3 Project real quickly, you guys know that we vote every day. Patriot Mobile has been such a great partner to us because not only does Patriot Mobile provide great wireless service on all the big carriers, so you're getting the same exact wireless service on AT&T, T-Mobile, and Verizon. They use the same exact airwaves and all that magic stuff that happens in the air. Same exact. But you get 100% U.S. customer service. I called Patriot Mobile customer service on Friday. The guy answered the phone, spoke great English, super helpful. Someone's going to call you right back, blah, 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 blah. You get someone on the phone that's in America that speaks English. I love that. You got great. I just got my wire, my puck, my hotspot set up with Patriot Mobile. I love this stuff, but they're an activist company. They're proudly an activist country, but an activist company that stands up for our values. First Amendment rights. They're pro-life. They help veterans. It's awesome. And that's the cool part. You are supporting a company that supports these things. You can get a free month of Patriot Mobile by going to patriotmobile.com/Spicer and use code Spicer for a free month, or give them a call at 972-PATRIOT. The cool part is they literally send you an email with a QR code. You put your camera up from your phone onto it, and it guides you through it seamlessly. It's super easy to switch over to Patriot Mobile, and you can feel good about it. It takes just a few minutes. Go to patriotmobile.com/Spicer, code Spicer, or give them a call at 972-PATRIOT. And then at the end of the day, once you've worked really hard, go to bed. I do this every night. I tell you guys all the time, look at this. Oh my God, look at how many bags of Beam Dream Powder. And look, I don't always play favorites. I've even got the brownie battered flavor right there, but you can see all the cocoa cinnamon one because I love that one. And they've got so many cool flavors. Now they've got a peanut butter one, and that one is right up there with it. But no matter what flavor you choose, 5 natural ingredients. The key word there is natural. Reishi, apigenin, L-theanine, melatonin, magnesium. I've got them all down. All natural. One blend. I use 30 minutes before I go to bed. I fall asleep like a baby, and then I wake up feeling ready to go. And that's the best part about it. You will fall asleep, you will stay asleep, and you will wake up after having a great night's sleep. So go to shopbeam.com. Use code Spicer for 40% off. I do not know when that discount will end. This is the best deal that Beam has ever offered. So if you are looking for better sleep, go to shopbeam.com/Spicer and use discount code Spicer for 40% off. Without further ado, I want to bring in Will Chamberlain of the Article 3. Will, welcome back to the show. Good to see you.
Good to be with you, Sean.
Before I get into a bunch of the stuff that's happening right now, obviously our thoughts and prayers are with Mayor Rudy Giuliani. I think things have gotten pretty polarized with the mayor in the last few years because of Trump. But just as somebody who's like very involved in the law and the Constitution, I mean, what do you think about, how should we view Rudy Giuliani's impact on like law and justice and the Constitution and all these cases?
Deeply positive. We forget, Rudy Giuliani was the mayor of New York on 9/11, personally responsible for bringing New York back from the brink of crime and disorder under David Dinkins. Like a lot of people were able to move to the city and have it be safe because of the stewardship of Giuliani and then Bloomberg. That was, really 16-year period where New York wasn't just it's just the biggest city in the United States, but also one of the safest. Obviously we've had some Democrats, especially Mamdani lately, who seem intent on reversing that progress, but he's an incredible mayor of a very, very important city. And then also as a prosecutor in New York, he was responsible for bringing down much of the mob. And he ultimately, I think, founded a major law firm. They took his name off the banner because obviously supporting Trump is just incompatible with big law. But he's a really a great man of America and in the early 21st century, and deserves a lot of plaudits for it. And, our prayers are with him.
Yeah. I hope, obviously he recovers. And I want to move on though to somebody who probably goes the other direction, which is Jim Comey. So why is this version of the indictment? What's different about this time that they're going after Comey than the first time?
Well, it's first off, it's where they're doing it, right? Where they're able to indict him. They're indicting him in the Eastern District of North Carolina and not in the friendly part of the Eastern District of North Carolina. This isn't Raleigh. I actually live in North Carolina, so I'm somewhat familiar with the geography.
Okay.
This is far east. This is New Bern, very, towards the Wilmington area. And there's not a lot out in Eastern North Carolina. People need to understand that. Like the population centers in North Carolina are central to west, Charlotte being the big one, obviously, in southwestern North Carolina. And then in more central North Carolina, you have Greensboro. And then sort of east central would be the Raleigh-Durham metro, the Research Triangle. How far east is where you get into kind of swampland. So that's not actually the very, very much populated area of North Carolina. Wilmington obviously is the big coastal town, but in sort of where he's at is New Bern. New Bern, I'm pretty sure, has a military base of some sort there, rural, Trump supporting. And so even where he has, he's got I think Comey had a beach house out on the coast, and his neighbors are not friendly, right? In terms of what he's going to be looking at in terms of a jury trial here. So he's not going to have a friendly judge. He's not going to have a friendly jury. So that's the first thing. The second thing is that it's just not going to fall victim to the kind of shenanigans that it doesn't have the Eastern District of Virginia judges backing him up. I think that's a big thing that happened. You remember about a year ago or so, he was indicted for making false statements to Congress based on his testimony. I don't remember exactly what the testimony was in relation to, but very quickly, the Eastern District of Virginia judges went after Lindsay Halligan, who was the U.S. attorney who brought the case. Said that it wasn't proper, and there was a bunch of other legal challenges that the EDVA judges, who obviously knew James Comey, the whole reason Lindsay Halligan had to be brought in is because the interim U.S. attorney in the Eastern District of Virginia was a friend of James Comey's, and so I think it might have been somehow a relation, honestly, like a son-in-law or something like that. So just totally he was dragging his feet for obvious reasons. And so then they had to bring in Lindsay Halligan last minute. That created issues with the EDVA. You name it. This is much simpler. He's now in the Eastern District of North Carolina with a U.S. attorney who's in place. He doesn't have as many good challenges. And so he's going to have to prevail on this theory that the 8647 statement wasn't a true threat. But the key thing to keep in mind here, if you listen to Todd Blanche on the Sunday show where he was interviewed about this, and you read the indictment, you realize, James Comey is a person whose public statements are, he was the FBI director. There's a ton of documentation about his thinking and his knowledge that is in possession of the United States government just by virtue of the fact that he worked for the United States government. And so the question of what he meant by 8647 is going to be in the context of the fact that we have a whole slew of other communications from James Comey explaining and shedding a light on what he probably meant by that. We also probably have some more communications from him more recently. So there's a lot there that the administration is able to work with, and they're able to prove this. And, I've seen a lot of people say, oh, this will get dismissed out of hand, obviously, because it's not really a true threat. But the federal prosecutors that I listen to, people like, not Adam Lowy, Jay Town, who was a U.S. attorney in Alabama, people like Bill Shipley, who was a 20-year federal prosecutor. Both of them have put out lengthy posts that say there's no procedural mechanism for Comey to make this go away quickly, right? Like his argument is an affirmative defense. He will have to go to trial to prevail.
Okay, so that's I didn't realize that. Like last time it got dismissed because they argued that Lindsay Halligan hadn't done the proper procedure, right? So that seems to be not the case this time, right?
Yeah, that's not going to be the case, right? Like he's just not going to be able to get it dismissed outright. The sort of question of the true threats analysis is going to have to be incorporated into the jury instructions. Right. It's going to have to incorporate it in terms of what does the prosecution have to prove. It'll have to prove more at trial, but he's not going to be able to just get out of it because it's not a block. Right. The whole point of my understanding of the true threats jurisprudence is you don't just get an early motion to dismiss. It's not like a defamation claim. Like you still made something that could be well understood as a threat against the president of the United States. And so at trial, the government will have to prove a higher standard of intent than they would have in other contexts, perhaps like a recklessness standard, which is more than mere negligence. But again, that's just a question for trial. The question is going to be whether or not the prosecution has sufficient facts to, demonstrate a reckless intent on the part of Comey. And there's no simple way out of it prior to that trial.
Okay, so let's just play this out for just a sec. But I mean, the bottom line is, my guess is that he initially says 86 could mean anything, right? And some people that I've heard on the left say that you use that in a restaurant or something. Maybe, who knows? But the bottom line is, why can't he just say? Because all he said in the post is, "I saw these seashells" or something. I mean, like, why can't he just say, they were there, or 86 means a lot of stuff. I mean, like, how do you ever prove intent unless he wrote it somewhere, like, hey, he texted a friend and said, yeah, I really think this is funny, or I wanted to do this. Or frankly, what if he just thought it was funny? What if he said, yeah, I wrote it, but God, you guys got to think, I mean, I wasn't serious. That's just being funny.
Well, I mean, intent is proven through circumstances all the time, right? Like, somebody shoots a gun at somebody, they don't necessarily make an announcement, I intend to murder this person, right? Like, you infer, juries are allowed to infer intent from conduct all the time and from context. So he will. So the government has to prove, though. I mean, because look, you cannot, I don't think anyone can say, if you're Comey and you were the FBI director, you either have to admit that you're incompetent and have no clue what 8647 means, or you have to kind of say, I was kidding. But you can't, you can't honestly expect anyone on a jury to believe that the FBI director has no clue what 86 someone means. Right. And the question is, like, what did he mean, or what should he have, what was he indifferent to explaining? All this is going to be in the context of his own statements about and what he was doing at the time. I understand he was just putting out a novel, and the novel had something to do with political assassinations right at the same time. So, given the context of his own conduct, of his own statements, the jury's going to get a chance to look at all that and make an evaluation of, obviously, James Comey's going to make all these arguments. I didn't mean it as a threat, blah, blah, blah. But the jury's going to be able to evaluate that and decide whether they think that's true.
I mean, so let me just ask you, like, knowing how you look at all these, like, on a scale of 1 to 10, with 10 actually doing time in prison and 0 being that he just gets nothing. Like, where would you rank this?
6, 5, 6, right?
Okay.
More likely than not.
Does he plead out? If that's the case, does he plead out and say, look, it was dumb. It was stupid of me. I'm willing to take a slap on the wrist because I don't want to risk going to jail?
I mean, it's a 5-year count and it's a felony. I don't know that he really wants to plead guilty to a felony count of threatening the president of the United States with murder.
Couldn't they offer him being a jerk for a misdemeanor?
Maybe.
I mean,
maybe there's like a slightly less thing, but I doubt it. I don't think this DOJ will want to go along with that. I think that they'll want, they're not going to let him plead to a misdemeanor if they're charging him with a felony. That's very uncommon.
But he has to, I mean, like, this is going to cost him, right? I mean, he's got to prepare for a trial and be ready. I mean, that in itself is a big deal.
Yeah. No, it's not going to be cheap, and it's not going to be simple either. So,
okay. We got a lot to break down. I want to talk to you a little bit about redistricting. So the court comes down and says that this Section 2 is a violation for racial gerrymandering. I look around the country. Massachusetts, for example, has a race-based district in the Boston area. What does states need to do to comply with this? Because it seems like a lot of them are saying we're just not going to do anything for now. Like, when you get a ruling like this, do they have to act? Do they have to act quickly? Can they act within a cycle? Can they ignore it?
Well, that's an interesting question. I don't think they can. I mean, I think it's going to depend on the lawsuits. And it's important to understand what the holding was. It wasn't that Section 2 is unconstitutional. It was that Section 2, properly construed, prohibits these racially gerrymandered districts, like intentionally racially gerrymandered districts. And all voters are entitled to be in a district that is not intentionally drawn to maximize or minimize the racial composition of whoever's in it. So, that might be an effect of just using other metrics that are permissible, but you're not allowed to use race as a metric. So I think any of these districts that had intentional racial gerrymandering are vulnerable to an immediate challenge in court. But that challenge might not immediately lead to a judicial order forcing the immediate redistricting, because obviously that comes into conflict with a bunch of other laws that say you can't force a redistricting a month before a general election or something like that, right? So there's I don't know the details of how that law exactly works, but basically what this ruling does mean is that every congressional district that intentionally was drawn with race intentionally in mind as a metric, that district is now unconstitutionally drawn and will have to be drawn in a race blind manner.
So when Harmeet Dillon says that the Civil Rights Division of the Department of Justice might start looking into this, should states be worried, or should they? I mean, to your point, could they? Hey, our primaries are underway. Like, give an excuse. Like, what should a state prepare themselves?
I think, well, Republican states should obviously take the opportunity to say we're not going to hold an election with congressional districts that were unconstitutionally drawn. We're going to fix them beforehand. So even if we have like a primary schedule, we're going to push it and we're going to fix the districts so they are, they are in line with the Supreme Court's holding in Calais. Democrat states that don't want to do that, or Republican states with rhinos that want to hold off, should expect litigation.
So I know this is a little bit of a flip, because in Virginia, where I live, we're going through a bunch of state stuff. And I get that this is, from what Ken Cuccinelli tells me, the former attorney general, it's all state-based stuff. But what I can't get my head around is, and I'll take the easiest one. The law in Virginia says you have to have 90 days between the second passage of any constitutional amendment and when people start voting. The Democrats argue that election day was in April. But the reality is that early voting started in early March, 45 days prior to that. Clearly, like, I didn't take math in college, okay? But I can count to 90, and that's not even close to 90. So why is something like that? As a non-lawyer, I don't even understand how that's not even an easy win for the Republicans to go in and say, it's clear that 90 days didn't exist between when you passed and when voting starts.
Yeah, I think they've got the best of the argument for sure. I mean, obviously, law is about how judges rule. Ultimately, it's a prediction about how judges rule, and so the judges will need to abide by their what seem to be pretty clear constitutional provisions. But if they stick by the law, I don't think the Democrats.
But why?
Have much of an
Here's what I don't
all.
get, Will. Why does, when people like you say that, what I don't understand as a lawyer is they'll say, well, if the judges follow the law. It sounds to me like judges go, well, that's the law, but I don't think it matters.
I mean, judges will, they can convolute whatever they want, right? This is, courts invented a right to privacy in Roe v. Wade. Ultimately, Supreme Courts of a state can say what the law means and say what the Constitution means. There's no federal right of appeal, right? The Supreme Court of Virginia is the ultimate arbiter of what the Virginia Constitution means and what Virginia statutes means. They're only constrained by the federal Constitution and that they're not allowed to violate it. But the federal Constitution doesn't speak on how states conduct their elections except in these sort of racial issues.
So what if Virginia had a race-based district in the Richmond area? Could then I sue under the new ruling and say, fine, but your current lines don't comply with the VRA ruling that the Supreme Court?
That would be exactly how you'd approach it. But that's not, I don't think there's any challenge, because I don't think that they used race intentionally in this. I mean, it was such a blatantly obvious partisan gerrymander, right? Like they took Arlington and Fairfax and like made that 5 or 6 districts or something.
Yes, 5.
Yeah, 5. So I think obviously it's just a partisan gerrymander, which the Supreme Court has said there's no federal claim about this. Like it's just not justiciable. We don't resolve these questions.
I know. Unbelievable. You mentioned Roe v. Wade. There's an interesting story evolving right now that is a perfect segue to this issue. That there's a federal appeals court that ruled that the abortion pill, it's called mifepristone, I think is the
mifepristone. Yeah.
It cannot be sold online by telehealth or mail. And there is now a Supreme Court apparently appeal that people are taking it up. So if a federal appeals court says that, it's now saying that you can only get it in person, you can't have telehealth or by mail issued, right? You'd have to go in, have it dealt with as a drug. When you look at a case like this, like what is it seen in light of the ruling of the Roe versus Wade, or is it some niche interstate commerce thing? Like, how does the court look at something like that versus Roe versus Wade or whatever? Like, what's the basis when they look at a case like that?
So well pre-Dobbs, it would have been evaluated under the sort of undue burden standard of Planned Parenthood v. Casey, and probably found federally unconstitutional as imposing an undue burden on access to abortion. Post-Dobbs, that's not even a rule anymore. Like, it's just gone. There's no federal rule about what you're not allowed to do when it comes to abortion. So I think the only real standard here would be you'd have to make some argument about how it's beyond the power of the FDA to regulate, I guess, because I am not deeply familiar with the details of this
Yeah.
case. So I assume it's like an FDA prohibition on telehealth sales or something.
Right.
So you'd have to make some sort of administrative law argument about how this is beyond the statutory authority of the federal regulator, or some sort of commerce clause argument that wouldn't fly either, because obviously that's interstate commerce. So I think my guess is, just even brainstorming it, like I'm not super familiar with the details of the litigation, but just brainstorming it, I don't really see how there's a very good claim that the plaintiffs could make here about why either a state or the federal government isn't allowed to impose a rule like this.
All right. The Supreme Court, though, in the same genre, is taking it says, story came out, Supreme Court sides with crisis pregnancy center in subpoena battle. And let me just read you a little bit from the story here, where it says the justices ruled that anti-abortion advocates can seek relief in federal court. The Supreme Court handed a win to anti-abortion advocates, ruling that crisis pregnancy centers can go to federal court to block a state subpoena that was tied to a probe of the center's fundraising practices. The unanimous ruling does not immediately shut down the investigation by the New Jersey Attorney General's office, but it means that centers will soon get a chance to argue to a federal judge that the state, this is obviously the state of New Jersey, was demanding fundraising related records going back a decade and apparently, obviously, intruding on the center's First Amendment rights. In litigation over the case First Choice Women's Research Center versus Platkin, New Jersey prosecutors argued that the centers may be misleading their patients or donors.
Yeah, so I think the basic premise of that litigation is like you're not allowed to just launch an investigation and start subpoenaing nonprofits because you don't like what they say or you don't like their speech. I mean, that's
amazing though that these
basic.
guys love to target, for all the talk about lawfare. I mean, here you have New Jersey and other states going after crisis pregnancy centers because they don't like what they're saying, and it's sort of like when the IRS was going after a bunch of right-leaning nonprofits as well.
Yeah, no, it's really, I mean, especially I read so much about how, President Trump is weaponizing DOJ or whatever, but we see what Democrat attorneys general in states do all the time. Like they just do this stuff just to harass their opponents, and it doesn't have they don't have any claim, like they don't have any legitimate criminal, they're like, well, theoretically, maybe they're deceiving people and misleading people. Well, you don't have any evidence of that. You didn't, I mean, so what are you even talking about?
Over the weekend, this is a total turn. Spirit Airlines filed for bankruptcy, and there was a bunch of debate about, number one, whether the government should be involved, should have bailed them out. Number two, it was to who is to blame. And when you go back, Spirit Airlines had filed for bankruptcy at least twice. And there was this pending thing while Biden was in office to allow them to merge with JetBlue. Elizabeth Warren, Pete Buttigieg, all these people opposed the merger under antitrust laws, I guess. And now they filed for bankruptcy. That's a lot of people out of jobs. It's a lot of consumers screwed. Is there like a legal, first of all, let's just start with this. I think the idea of the federal government getting involved in bailing out a company, is there any legal issue with that?
You need statutory authorization, I think. But if you had a bill to do it, then there wouldn't be a problem. But I don't think that, unless there's pre-existing statutory authorization from sort of a generalized fund that maybe exporting, I don't know. I'm trying to think of who might control it. But my intuition is there's nothing stopping. We've had millions of bailouts before, right? Like if Congress decides they want to spend taxpayer dollars to bail out a private company, then they're allowed to do that.
But in this case, the merger that Elizabeth Warren celebrated blocking, this with JetBlue, would have potentially kept them flying. But the DOJ, it was under Merrick Garland, the former attorney general, that said they can't merge. What is it? Just, I don't understand. JetBlue is not like a behemoth, not like some massive airline. Spirit, obviously low cost, regionally based aircraft or company, airline rather. What was like? I know you may not know the particulars of this, but like somehow they were proud of blocking that. And yet many big companies merge all the time.
Yeah, I think, they had some notion in their head that if they prevented the merger, then you'd have increased competition among low-cost carriers to really, really keep costs lower than ever. But I think that they just underestimated the real risks to those carriers, that they were much more fragile than they realized, and that they really would do better if they were in one. And ultimately, They didn't. The idea of there being a monopoly in low cost carriers is just sort of a contradiction in terms. There's not a monopoly. Wouldn't have had anything close to a monopoly in terms of aircraft service. I mean, obviously, even the combined operations of JetBlue and Spirit would have been less than 10% of the domestic flight market when you have American, Delta, and United being much bigger, all three of them. So I think it was a really, really stupid approach to antitrust. This is not a group that would have had meaningful pricing power, and now Spirit just ran headfirst into a wall, apparently, and just went bankrupt, and a whole bunch of people with flights suddenly not in a position to do anything anymore.
No. And this is the stupid part. I hope people will remember this is exactly the consequence of Democrats. I mean, they literally, there are people out of a job now, pilots without seniority, and there are people that are screwed in their traveling because Democrats thought that they knew better.
Yeah.
Let me ask you about the court, though. We've got a lot of issues left on the court docket, as far as I can tell, like mail-in balloting at the RNC, birthright citizenship. Paint a picture. Like what does it look like? Is it by July that we have to have an answer? Can they punt? Like what should we expect while this court is still in session?
I mean, I think they try and get all the rulings out the door by the end of June. I mean, I think there's a few big ones coming. I think they heard argument in the TPS case, which is temporary protected status. That's a big one I have my eye on, where you've had district court judges repeatedly stop the DHS secretary from, revoking TPS status for people. I mean, remember, TPS is temporary protected status, and there's literally a congressional statute that says the determinations of the DHS secretary are unreviewable by district courts. And yet district courts have just blown past that, saying things like, well, we're not reviewing the determination. We're just making sure the procedure used to get to the determination was followed. Nonsense, right? They're going to get smacked down. They've been getting smacked down. And yet basically they've been getting smacked down in like per curiam brief orders that don't explain things. And finally, the Supreme Court's like, you guys aren't getting the message. We actually need to have an argument on this and then end this procedure. And that's what's happening now.
And this RNC mail-in case, where it talks about, I mean, it really, in my mind, defines what election day is. So the case is, when does election day end, is probably a better way to put this. The court is getting this question as to, hey, these ballots are coming in over and over again, days after the election, and there's a desire to settle that. Is this the kind of thing? I know the court always hates getting involved in politics, but understanding when election day ends is a federal issue, because if I'm voting in Virginia and you're voting in North Carolina and you have 3 extra days to get your ballot in because of when you mail it, and mine gets cut off in Virginia, our votes in theory aren't equal.
Yeah, and also, I mean, there's just an obvious fraud prevention metric here, right? Like insisting that the votes come in on election day means that you just can't manufacture votes in the future. There's a lot of reasons why that election day requirement is really strong. I think, and if I remember, that oral argument was a while ago now, but if I remember that oral argument, it didn't go well for the people trying to say election day didn't mean election day. So I think we're finally going to get rid of, and that would be a real boon, because it would mean we get rid of this endless waiting for ballots to come in. That happens in places like California.
I mean, I think that would, if that comes through, so like, let's just say the court issues a ruling, that would affect this cycle, right? So you couldn't, if Maryland or whatever said, we're going to allow ballots to come in 5 days with no signature, they would have to abide by it this cycle, right?
Yes, I believe that's right.
And they can still do whatever they want on their state election, but that would impact, like, if there's a race for Congress or president or Senate, that has to be the case, right?
Correct. Yeah,
okay.
If it touches a federal office, yes.
Okay, so that's one of the big ones that I know I and the RNC are all keeping an eye on as well. Then the court's also looking at this birthright citizenship question. By the way, before I move on, I just want to be clear, though. To my question about politics, is there a way in your mind that the court, like, I guess what I'm trying to figure out is, I know the court doesn't like dealing with politics, as I stated to you, but like, how do you, it almost seems to me as though they have to answer that existential question. When does election day end, or when is it, right? In your mind, is there a way that they could weasel out of an actual answer?
No, I mean, they're going to say what it means. They have to say what the law means. I don't know how they get out of it otherwise. So
okay.
The answer is no.
On the birthright citizenship, walk us through how you think something like that plays out, because a lot of people, I mean, you talk about like TPS. I mean, there's a big issue. We saw the 60. Peter Schweitzer's got a brand new book out. He talks about all of these Chinese that literally will fly over to have a baby. I mean, like, there are places in California that are set up just to take care of women who are pregnant for the final months so they can have a kid here, fly home, and have that kid have U.S. citizenship.
Yeah. So, I mean, I think that's a really, really close case. I think the people who've said this one's obvious were wrong. And the briefing, I think the government's position on the briefing was stronger, which is surprisingly, I've talked with Ray Barnett and a number of the serious original scholars, and they basically said, nobody had ever really done the originalist research on what this phrase meant prior to this year, because everybody kind of assumed it meant everybody, if you're born here, period, you're a citizen. But you look into the meaning of that phrase, subject to the jurisdiction thereof, and you realize, like, the framers of the 14th Amendment were considering things like, what the children of temporary sojourners, and they thought, no, those people clearly are not going to be citizens under this rule. And it was indeed designed for the children of freed slaves. And I think the really best example of why this is not a simple problem and that the government has a pretty good position is how American Indians were treated. The children of American Indians, even if they were born on the territory, were not seen as citizens because, while we had open borders externally in the 1860s and anybody could, come and there was no visa system, we had closed borders internally. Like, American Indians were on their own reservations and were not allowed to just migrate willy-nilly into the interior of the United States. And so their children were treated in similar to how we would think of, the children of aliens now today, because they really were aliens. And so, and as a result, nobody thinks the children of American Indians were entitled to birthright citizenship. And indeed, they had to be granted citizenship by statute in the 1920s, which sort of is an important point to remember. Like, whenever somebody talks about horror of horrors, God forbid, the Supreme Court says you're not entitled to birthright citizenship as a matter of constitutional law. Congress has the power of naturalization. So if you think there are any hard cases that would result from an adverse Supreme Court ruling to the people who would benefit from this, then Congress in their wisdom can fix it. But when you actually start looking at, like, who are the beneficiaries of birthright citizenship under the rule proposed by the ACLU and their friends, well, it's the children of two illegal aliens unlawfully present in this country. Like, why? What? Like, think about what that means. It's like two illegal aliens in this country, neither of whom has legal status, had a child in this country. Why is that person entitled to citizenship? And why on earth would we structure our immigration system to encourage such enormous lawbreaking? It's crazy. So I doubt that Congress would agree to that if they ever did it. And I certainly don't think that the framers of the 14th Amendment would have assumed that they were facilitating birth tourism as an industry into the United States with their birthright citizenship rules.
So if two diplomats are in the United States, an ambassador or someone who works in an embassy from another country has a kid here, that kid's not granted citizenship. That's always been the case. So I don't understand why, if you're in this country illegally and you have a child, that's not considered the same thing as being in the country as an ambassador.
Yeah, I think and that's the point that the government's making. And the way, and you have to understand the way that the challengers, the ACLU types, are framing this issue is they say, well, subject to the jurisdiction thereof, that phrase has a bounded meaning to the exceptions that were that were identified at the time of the framing, namely, like, foreign invaders, children of diplomats, and that's it. And there are no new categories of individuals who could be not subject to the jurisdiction thereof. And the point of the government is like, well, then why didn't they just list those exceptions when they wrote the 14th Amendment? They didn't do that. They created this general rule. And it stands to reason that if you create a general rule like this, you're saying there could be other categories of people in the future who might be identified as not subject to the jurisdiction thereof. Because, diplomats, for example, are obviously, while they're here, subject to the legal jurisdiction of the United States to some degree. Like, you're not allowed to just violate traffic laws willy-nilly, for instance. You're not allowed to murder people. So it can't just mean, oh, well, you have to obey the law. Everybody has to obey the law. Subject to the jurisdiction was a term of art in the context of immigration law, and it had, I think, Ilan Werman and Randy Barnett and Kurt Lash, the three big law professors on this, have explained that it's intimately connected with allegiance to the United States. And so, and allegiance is also therefore connected to domicile. And you can't set up a legal domicile in the United States if you aren't present legally. Your domicile as a legal matter is in your country of origin.
That's fascinating. So in my mind, I think there's two categories here, right? And one category are people who are not legally in this country, not subject to those laws, right? But then here's the thing: at least walk me through this. If I am, as Peter Schweitzer documents in his book, if a bunch of people come over here legally from China, and let's say they have a 30-day visa, so they come here, at their 29th day, they sit at these hostel type apartment places in California, have their baby and leave, then would their kid be considered citizenship because they were in the country legally, or because they didn't come here, they came here expressly to have a baby? Is that a separate? I mean, like, I guess what I'm trying to figure out is there a nuance in that.
I mean, I wouldn't be surprised to see the Supreme Court try and split the baby on this. Maybe they let the children of illegal aliens keep their citizenship, but not the children of like clear, obviously temporary visitors, in an effort to kind of not allow birth tourism to make a mockery of our citizenship rules. And how you'd enforce that is really a question for the executive branch, because all the Supreme Court would be saying is you are allowed to not grant citizenship to these children if you choose. Right. That's all they would be saying. It's a constitutional matter. There's no prohibition, or there's no constitutional right to citizenship for the children of these birth tourists. And then it would be up to Congress and the executive branch to make laws if they so and issue executive orders if they so chose to make that reality. So implementation is just a different question. It's really not what the Supreme Court has to concern itself with.
Okay, but when you say that, what I'm trying to discern here is, does the court rule on this, like saying if you are in this country legally, you are not given citizenship? Or does it say Congress has the right to implement a law that would say this and basically kick the can to Congress to do that?
Yeah, I mean, well, I think any Supreme Court ruling effectively kicks the can to Congress and the executive branch to actually say what the law is, right? Because again, Congress has the power of naturalization. They can say anybody's a citizen who they want to. The executive branch is responsible for implementing immigration law. Basically, all the Supreme Court will make a decision about is, well, what does subject to the jurisdiction thereof mean? And what is the floor for people who are guaranteed citizenship, right? And they can just say what categories of people are constitutionally entitled to citizenship under the 14th Amendment. That's all that's so, everything beyond that, like, is going to be up to the other branches.
But that we should expect that to get ruled on, right? There's no reason.
Yeah.
Okay. So by whatever you said, the end of June, we should know what they're doing. But in your opinion, like, let's say the court rules that people who are not subject to the jurisdiction as they define it, would that immediately take away citizenship, or would Congress then have to follow up?
Well, the executive, there's a statute that's the language of the statute runs identically to the Constitution in terms of who's entitled to citizenship under our immigration laws. And what spurred this litigation in the first instance was the fact that the Trump administration issued an executive order saying, we are interpreting the statute to mean that the children of illegal aliens are not citizens and will not be granted it. So that's essentially why, that basically saying Congress, the court would be saying that executive order is constitutional if they rule in favor of the government.
Got it.
And so that executive order was prospective, right? It only meant that it only applied going forward. It didn't look back. So basically, I don't think we'd be under current law stripping citizenship from people who'd already been granted it under the previous set of rules. And to do that would be very tricky because it would run into other problems in terms of their, it's a lot. Once you granted somebody citizenship, stripping it, my understanding is, I'm not like super deep on this, but it's much trickier legally, and there's other protections because your citizenship isn't, I don't think it's something that can be stripped from you without due process, and et cetera, et cetera, et cetera. So I don't know exactly what the problems are, but the lawyer intuition in me says it's a lot harder to strip something from strip citizenship from someone than it is to say people in the future who are born under these circumstances will not be granted citizenship.
Got it. That makes sense. The last thing I want to ask you is that there's this pending case, Trump versus Cook. Lisa Cook, the Federal Reserve governor that Trump tried to fire. So two things, and before we wrap, I just want to understand, why is this case taking that long? It seems to me that that's a pretty simple question, whether the president has authority to fire her or not. And then secondly, I assume that at least what, unless I'm missing something, that this should be a simple question of the Fed the executive has to have the ability to do this?
Interesting question. I don't know. I mean, it could be that the liberals are dragging the feet on the dissents because they want to keep the status quo in order as much as they can. I mean, Molly Hemingway wrote a great book, which went over in detail how the Democrats refused to release their Dobbs dissent, even as the Dobbs the Dobbs opinion had already been leaked, and there were being threats on the conservative justices. So, and clearly also it looks like Judge Kagan dragged her feet on her dissent in Louisiana v. Calais to try and create some issues for redistricting.
Hello.
So that could be what's going on here. It also could be that this is a hard case. And I mean, the Federal Reserve is a tricky one because the question is, it is the quintessential independent agency and the best sort of policy case for having people insulated from presidential removal. And yet I think that the way the Supreme Court has been going in so many other cases is that basically the unitary executive isn't a theory, it's fact, it's the Constitution, and the Federal Reserve, given that it's obviously, engaging in executive branch activity, needs to be subject to executive branch removal. And I think my guess is, if I had to bet on what's happening, I think it's, the Supreme Court's going to say they can fire Lisa Cook, and the liberals are foot dragging on the dissent.
Exactly. Will Chamberlain, appreciate you joining us as always. Thanks for everything you and the Article 3 Project do to keep us informed and keep those guys honest.
Absolutely. Happy to do it.
You bet. All right, guys, what a great show with Will Chamberlain. I love his analysis. I mean, think about this. Do you really think the FBI director didn't know what 86, which is like slang? So when you 86 somebody, as President Trump said, that was a mob term. When you 86 47, right? It doesn't take a degree from MIT to know what he's talking about. So important. And this time it looks like he's really going to court. I didn't realize that. And the way that Will broke down those cases is phenomenal and fascinating to me. There's so many important things. What election day really means. That's critical. And the Dems don't want it to end. You notice this, right? How it's just, there's so many cool things that are going on right now in the courts that will really affect how we deal with things. Birthright citizenship. I'm telling you, I've been trying to get Peter Schweizer to come on the show. It'll soon happen. But there's literally like baby farms where they're bringing Chinese women over, putting them up in these like hostel type apartments in California for them to have a baby and then flying them home and their kid. So we're talking about tens of thousands of Chinese nationals that have U.S. citizenship. That's why that case is so super important. Anyway, we've got a great week headed your way. Continue to stay with us. Sign up for those notifications and subscriptions. And go on Amazon, order Trump 2.0. Feel free, if you're in the D.C. area, to join us at the Trump Kennedy Center May 15th. Tickets are free. Go to SeanSpicer.com. We'll see you back here tomorrow. Well, if you enjoyed this content, make sure to like this video, subscribe, and click the notification bell to get more.